All right, welcome to this In-House Counsel Network webinar call, co-sponsored by Holtzman Vogel. Today, October 14th, 2025, we are delighted to host State AGs and the Supreme Court 2025 term. My name is Vera McIntosh, and I'm the Assistant Director of Strategic Partnerships at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's call, as the Federalist Society takes no position on particular legal or public policy issues. In the interest of time, I'll keep the introductions brief, but if you'd like to know more about our panelists, you can access their full bios at fedsoc.org. Today, we are fortunate to have with us David Johnson as our moderator. David is a partner at Holtzman Vogel and focuses his practice on political and election law, regulatory compliance, appellate law, and state attorneys general investigations and litigation. Prior to joining the firm, David was policy director and general counsel to the Republican Attorneys General Association, as well as serving as president for the Rule of Law Defense Fund and Center for Law and Policy. In these roles, he worked closely with Republican attorneys general and their staff on developing and advancing policy priorities. He has also worked with President Trump's administration and other leading Republican political and conservative policy organizations with respect to key policy initiatives. Previously, David was senior counsel with the Office of the Indiana Attorney General, where he advised the Attorney General on strategy with respect to litigation, communications, complex legal objectives, and policy goals. Prior to joining the Indiana Office of Attorney General, David served as corporate counsel for Lawrence, Indiana. In that role, David advised on myriad issues, including municipal bonding, human resources, and capital projects. And before that, David served as Deputy General Counsel and Policy Director for Governor Mike Pence, providing strategic counsel to the governor on litigation, policy, crisis communications, and legislative strategy, as well as guiding policy efforts on gaming issues in Indiana. He earned his AB from Wabash College and his JD from the Indiana University McKinney School of Law. Two last notes before we kick off. As a reminder to any attendees that are seeking CLE credit, we will be posting a CLE code in the chat box at some point during the presentation. Please write this code down because you will be required to provide it at the conclusion of the webinar when completing your attendance reporting form. And lastly, throughout the panel, if you have any questions, please submit them through the question and answer feature at the bottom of your screen so that we will have access to them for when we get to that portion of the webinar. I will ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you for being with us today. And David, the floor is yours.
All right, thanks, Vera. And thanks everybody for joining us today. And thank you also to the Federal Society for hosting this webinar on state AGs in the Supreme Court 2025 term. I'll run through a brief intro of the panelists today, and then we'll get into some kind of high-level topics before diving into some of the cases before the court in this term. So with the intros, start with Eric Wesson. Eric is Iowa's Solicitor General. Before that, he clerked for the Honorable Jim Ho on the Fifth Circuit and John Ness on the Northern District of Illinois. And prior to coming over to the Iowa Attorney General's office, Eric spent some time in big law firms in Chicago. Also on the panel, we have Mark Pinkert. Mark is an appellate and litigation partner at Holtzman Vogel and the managing partner of our Miami office. Before joining Holtzman Vogel a year ago, Mark was at a global law firm, and prior to that, clerked at the 11th Circuit of Court of Appeals and the Southern District of Florida. Next up, we have Mo Jazeel. He's out of Holtzman Vogel's Tallahassee office, and he has been first chair in over 20 trials and argued over 20 appeals. As a Miami Dolphins fan and Florida Gators fan, Mo swears off football from Monday through Friday, only to watch his teams lose on Saturdays and Sundays. And I guess he swears off football during the rest of the week because he can only handle so much losing. Next up, we got Brandon Smith, who is the former chief of staff to Tennessee's Attorney General. He leads our Nashville office and advises clients on complex political, regulatory, and litigation matters. When he's not advising clients, Brandon's focused on his favorite roles as a husband, soon-to-be dad, and reluctant handyman. So we'll start just kind of with some of the trends with state AGs at SCOTUS and some of the topics, but kind of lay the groundwork. State AGs have played a major role in some of the biggest cases at the court over the last several years. And we've kind of seen an increasing role of state AGs as policymakers. And I think that's kind of bearing out at the court with the different types of cases that they're bringing. From Massachusetts versus EPA, West Virginia versus EPA, Dobbs, Grametti last year. And then, obviously every year Texas is going to have several cases. State AGs are kind of at the forefront in a lot of these legal battles. So, just to kind of kick things off, I'll open it up to the panelists. No real order necessary, but what are some of the biggest issues that you guys are seeing coming up to the court from the state AG's offices?
Yeah, I
Sure.
think what's striking is that the real constitutional dialogue now seems to be happening through state AG offices. They're not just enforcing state law, they're helping to shape national constitutional norms and driving the conversation about what's next in constitutional law. Whether you agree with the particular cause or not in any given case, it's federalism in action. 50 independently elected or selected lawyers testing the limits of the Constitution in real time. It's the front lines of constitutional law at this point.
Yeah, and I'm kind of interested in how that trend has come about. I mean, I think state attorneys general have always been in front of the Supreme Court and in federal courts. They've defended state laws against constitutional challenges, but it's really interesting to see this trend over the last decade or so. I think, there are probably a number of factors that are playing into this. I think you mentioned, David, Massachusetts versus EPA, in which the Supreme Court held that states have a special solicitude in Article 3 standing analysis to go into federal court. We've seen lower courts more receptive to novel constitutional theories challenging state law and policy. We've also seen, political polarization at the national level, and I think a lot of special interest groups, lobbyists, donors, voters are demanding of state AGs to get involved in those national legal controversies and sometimes culture war issues. And I think, we've really reached the apex of that now in the second Trump term, where, I mean, there are quite literally dozens, I don't know, maybe triple digits of lawsuits by states against the administration in areas ranging from federal funding, immigration, education, gender affirming care, environment, offshore wind, things like that. So this is really the apex of that. I'm not sure that at any point in history have state attorneys general been so involved in national legal controversies.
Yeah, and sort of to a certain extent, the states defensively have become a microcosm of the United States' macrocosm, where all of the fights that you're seeing play out on the big stage relating to universal injunctions or remedies available under vacatur are playing out as well in the states. There are many states who pass laws, and then there are challenges to those laws that are facial in nature. The question of what a court is to do about that, what relief is available, what must be pleaded in state court or in federal court are all open questions that are percolating right now and making their way up to the Supreme Court. And then there's the dual track post CASA view of class actions or other. So class actions are available to private plaintiffs, but are not available to states, or at the very least, I've never seen a class action brought on behalf of a class of states. But states have, whether through their parents' patriae authority or through other mechanisms like the traditional police powers or just broader grants of statutory state authority, like under their UDAP or Consumer Fraud Act statutes, ability to seek broader relief than an individual or even an organization may be entitled to. And so on the one hand, you see that being used as a sword by blue states, but you're also seeing that same sort of fight conversely by the red states or blue states too when they're being sued by groups that disagree with the laws or policies that are being enacted.
Yeah, and just one more quick thing to add to that I find to be an interesting trend, and I'm not sure if there's sort of empirical backing for this, but I think more so than ever, we're seeing multi-state efforts and aligned joint amicus briefs where you'll have blue states all together in a multi-state action or on an amicus brief. And so I think that is a sign of our times, as Eric was saying, a stark political divide, the interest of one individual state. Um, you know, New York and California have all different industries and different interests, but they're together on a lot of briefs and a lot of actions, for example, challenging the Trump administration. So just an interesting sign of the times.
And as Nate Raymond at Reuters noted yesterday, one thing that unifies the blue states is a desire to sue the administration in the First Circuit. I think he counted 72 actions challenging President Trump in the First Circuit Court of Appeals. Of those, 51 have had preliminary decisions issued. 46 have been against the administration. Although the fun fact that wasn't in the article that I like to add is that 0 of those have been affirmed by the Supreme Court. There is a 100% reversal rate of those orders by the time they make it up to the court. So there's definitely some interesting strategery afoot.
Yeah, it's almost become like a form of federalism diplomacy, persuasion through numbers. And you've got 25 states signed on to a brief or an amicus brief on an issue that's emerging. It's not just a signal of where the politics are. It's really a signal of what ideas are getting traction generally. These briefs, either in the direct challenges or in sort of the corollary amicus brief practice that's often alongside some of these challenges, is a really interesting form of intrastate competition. I don't think it's going to be slowing down anytime soon.
Yeah, and as we look ahead towards both this term and kind of in the future, a lot of the issues that the AGs are working on, there have been whether energy issues, free speech. We'll talk about some of the transgender issues in a little bit, but some of that has some intersection with AI. And talking with folks, that seems to be kind of top of mind for where things might be going. I'm going to throw you guys a curveball. I know we didn't really talk about this, but do you guys see any, or do you want to kind of pontificate or hypothesize about where things might be going in terms of some of these issues and the intersection with AI and AGs?
I think even beyond AI, I think generally with the internet, with big tech, with platforms, and certainly in the future with AI, I do think that unless there is legislative action from Congress that has some sort of unifying regulatory scheme, that state attorneys general and state lawmakers will inevitably fill the gap. And we've seen that in big tech and in platform litigation, where state attorney general are really leading the charge to deal with issues that arise from the internet. So again, it's just a matter of, can Congress get together and come up with a comprehensive regulatory scheme? I don't really think that's likely, given how polarized things are and how Congress has been functioning. And so I think the result will be that state attorneys general fill that gap in the AI space.
I'll also flag there are already laws on the books that prohibit certain practices as to minors, especially minors under the age of 13, both federally and in the states. And a lot of the potential harms that are recognized by statute there relate to tracking data relating to those people. There has been a lot of litigation about age ratings and age identification in various types of websites, especially pornographic websites. But putting that aside, a lot of these AIs and LLMs are tracking every input that goes into them. And if they are not specifically excluding the data tracking for under 13 minors, they are opening themselves up to a whole can of worms, or a Pandora's box, if you will, whatever mixed metaphor you prefer, of liability. And that's just the start of it, because I will say, in my perusing, I have noticed that sometimes the disclosures these companies make do not perfectly track their own practices. And that also creates a lot of potential liability. And that doesn't even touch on what I think will eventually work its way up to the Supreme Court, which is fair use of information and data. If Chat GPT or another AI, I guess any AI, that's just the one that comes to mind. It's almost like Googling something, uh, is reading every book ever written and using that as part of its training set. You've already seen lawsuits from authors trying to get some value for that use. I think that those questions are very important as a basis for our intellectual property regime and are going to also make their way up. Although I don't see so far too much state engagement on that. I think that's more on the private side.
Wait, do you guys see this as an area, a rare area where the blue state AGs and red state AGs can actually agree on something?
It's
Or-
interesting.
Yeah.
So I believe there was an amicus brief, and there are a bunch of these lawsuits. So please excuse me if I'm wrong, but supporting Tennessee's
Yeah.
social media addiction law, basically challenging certain practices by social media companies that they believe are addicting kids to use the platform. And I think there was a bipartisan group of 35 states that signed on to that brief. So this is really at the forefront of an area where it seems like red states and blue states agree there is a problem. And maybe when you get down into the nitty gritty, there isn't a perfect agreement on the solution, but at the very least, there's an agreement that these laws, generally speaking, should be allowed to go into effect or largely should be allowed to go into effect.
You look at that, Chat GPT and AI are bringing the country together. The thought.
I mean, I'd also say historically, conservatives and liberals have had have at times not been big fans of big tech, but for different reasons. So, whether it's censoring conservative speakers versus, the political power and money, those issues coming from the left and Lena Khan, FTC. So sometimes they have similar goals, but for different reasons. One other point on data privacy, though, that I think is important to a point that Eric made, which is that there could be some federal law in point, and he mentioned one, I believe he's referring to COPA, which also gives state attorneys general parens patriae standing, so they still have an enforcement role to play in that space. But even beyond what the federal government does, there's going to be a patchwork of data regulation, data collection regulation, and platform regulation at the state level. And to some extent, a state like California, for example, could effectively impose its data privacy law nationwide just because of its size and influence, and to the extent that it has a law that a platform may want to comply with. There's an incentive there to just have a uniform policy across one's platform. So I do think the states, the privacy laws that are on the books at the state level will give the state attorneys general a really big enforcement role going forward.
Yeah, it's fun to talk about this during a government shutdown because I think it shows exactly why state AGs have become such significant actors in both cultural issues, but also in private sector issues. When there's a lack of clear statutory or regulatory guidance at the federal level, state AGs have been and probably will continue to fill that gap and use the tools that they have already, while state legislatures develop new tools for them to use. And that process has really kind of filled in the space where regulatory agencies or regulatory enforcers would have been acting in the past. And now some of the most innovative approaches to how to deal with emerging issues, both in like the AI and data privacy space, are not being generated by Congress, but are instead being generated by state AGs, both on the R side and blue side.
Yeah, those are all really, really good points. And I think it'll be interesting to watch how some of these issues percolate through the courts, through litigation and those other functions from the AG's offices. Turning to the cases before the court in this term, we'll start with Little versus West Virginia, the B.P.J case. My initials are D.P.J, so when people say it, I think they're talking about me, but they're not. Eric, I'll turn it over to you for a quick introduction and discussion.
Yeah, so Little v. Hecox and West Virginia v. B.P.J. Arise in similar circumstances. These questions arise from states that pass laws protecting girls' sports. And the question is whether males that identify as women are allowed to participate in those sports. So they sued seeking to challenge the laws. Those have made their way up to the Supreme Court. And in the wake of the Scrimeti decision last year, which found that in certain age-related and medical contexts, that states could enact laws protecting children from experimental sex change related surgeries, that perhaps states also have the authority to protect girls from males participating in their sports. Now, what's one interesting twist of this case is the the plaintiffs who've been suing, and these cases have been going on for years. They've gone up on appeal multiple times. I believe, if I recall correctly, the law in Idaho in Little v. Hecox has been had its enforcement enjoined for 5 years. The Supreme Court granted cert, and the attorneys in that case tried to dismiss their case with prejudice to moot it out. And that was a very odd move because normally when the Supreme Court, takes a case, the expectation is that they get to hear it. Sometimes after the Supreme Court takes a case, there's a settlement or something along those lines that gets rid of it, but that wasn't present here. And it is particularly interesting given that some of the attorneys in the Little case uh, were recently interrogated by a district court for improperly dismissing a case in an attempt to try to find a judge that they preferred to hear it. And so the context and atmosphere really does not appear to be helpful for them. I'm interested to see what the Supreme Court does, whether they accept this or whether they review it as gamesmanship. But ultimately, because the other case is still live, it seems very likely that the Supreme Court is going to issue an opinion that will help define the scope again about the relationship between the federal and state governments, between the states and the Constitution, and what can be done when it comes to regulations that touch on sex and gender. And I do want to flag that in these cases, Arkansas and Alabama both led amicus briefs with many states, as they have for years. I've been in this role for almost 3 years now, and I think between Little v. Hecox and West Virginia v. B.P.J., Iowa has signed on to, I think, 5 amicus briefs in the 2 cases, which is kind of wild as you wait to see these cases go up and go down. But yeah, I think these really set the stage. It's the next front in the court determining what role it's going to have in making decisions relating to sex and gender identity. We've seen this in Scrimeti. We saw this to a certain extent in Bostock. And now we're going to have these 2 cases. And I anticipate that as the issue remains live and there are differences in opinion about what is and isn't acceptable regulation, that we're going to see more laws going forward, maybe even some type of federal law. And then you're going to see challenges to those laws. But I think right now the states are in the driver's seat, and not having listened to argument yet, my expectation is that they're probably going to win, probably 6-3, and that we'll see what happens, what cases spring from that decision after.
Can I ask you a question, Eric? I think one important question that the Supreme Court didn't answer in Scrimeti is whether transgender is a protected class and regulations would be therefore subject to heightened scrutiny or strict scrutiny. Does the Supreme Court have to answer that question here in either of these cases, either because it's squarely presented, or to your point about whether it wants to take up the case? It would seem prudentially it would make sense to answer that question now, which would, going forward, make these sorts of regulations much more clear for states and how they pass laws, whether it's with transgender athletes or bathrooms or medical procedures. I think without that question being answered, it's you're still dealing with that difficult threshold question of what's the level of review.
Yeah, the answer is they don't have to do anything. They can assume without deciding that a law survives intermediate scrutiny And so whether it's intermediate or rational basis, they don't need to get there. You saw a little bit of that in the Scrimeti case, and the way the majority dealt with it is by recasting it as the regulation in question relating to certain medicines and medical procedures for minors as not being about transgender status at all. I think that would be a little tougher here, but if the court believes that these laws survive intermediate scrutiny and that even if there was a protected class, that intermediate scrutiny would be what applied, it is not hard to see, some kind of split decision again where everyone agrees or six justices agree the law survives and there's some split over what the standard of review is, which is very similar to what happened in Scrimeti. We have at least three justices that have indicated skepticism that transgender status is a protected class. I wouldn't be surprised if there were two more or three more justices that agreed with that. I'd be pretty surprised if there were four more justices that agreed with that. But if they don't have to answer that, I sort of think they won't. But at some point, given all of the flurry of litigation around these issues, it makes sense that they'll have to do it. And this might be the case to do so. To put on my legal realist hat for one moment, a lot of times the Supreme Court issues big decisions in areas where it is taking a position that aligns with what a majority of Americans thinks. And the women's sports issue is a very clear winner for the court if they side with the states. And I wouldn't be surprised if that's the vehicle that they choose to clarify some of the more difficult aspects of the law, because they'll be doing so in a context that is familiar and understandable to both the attorneys and the parties, but also to readers of popular news sources that'll be reporting on the decision.
Yeah, and I also just one more quick point on that. I also think there's an issue with vertical hierarchy in the courts right now. In many cases, lower courts are either not fully understanding Supreme Court precedent or trying to evade it in creative ways. And I think that without deciding that critical question again, I think the Supreme Court is going to allow too much confusion in the lower courts, and that's been a problem in some of its cases in the past. And I think not only for the states to know how to regulate, but also for lower courts how to deal with challenges to these types of regulations, I think it would be helpful for the court to definitively answer those types of questions.
Yeah, definitely. Moving on to the next case, Eric, we're going to stick with you on Childs v. Salazar.
Great. And at the risk of taking up too much time, I'll try to be short. Childs v. Salazar is one of the highest profile cases of the term, and I would say is the highest profile case that is yet to be argued, although two of my colleagues in the state SG community are arguing cases tomorrow in a redistricting case that I think we're going to talk about in a Fourth Amendment case. But Childs v. Salazar is the most recent in a series of cases coming out of Colorado where private parties have challenged Colorado laws or regulations on the basis of either impermissible viewpoint or religious discrimination, this one being viewpoint. Kathy Childs is a talk therapist who wants to treat her patients, and treating her patients may include counseling them that they may be happier, for example, in the body they were born than in a body that requires constant medication or surgical changes. And Colorado made that illegal. This challenge is a First Amendment viewpoint and content discrimination based challenge. I would not be surprised, based on the argument that happened, if that therapy is supported by more than even six justices, or at the very least that the standard of review the 10th Circuit used is found to be improper by more than six justices, and that they agree that strict scrutiny is correct. And maybe there will be a disagreement about what to do on remand, whether it should be sent back to the 10th Circuit to reassess, whether they should find, applying strict scrutiny, that the regulations or law don't survive. I think that that's probably what they'll do, but I'm not quite so sure. And really, this is, Justice Jackson asked an interesting question, which is, in Scrimeti, you said a state can regulate certain medical procedures. You being the court, we said you can regulate certain medical procedures. And now you're asking the same court to say that you can't impose regulations relating to talk therapy. What's the difference? And the answer given by the advocate was the First Amendment, because the First Amendment protects speech and it doesn't protect medical procedures. That may not be a satisfying answer to some, but it is a meaningful distinction because some categories of speech or even expressive conduct are protected by the First Amendment, and others aren't, and that can lead to a legal difference.
Yeah, I agree with that. I think it's likely a 7-2 decision. It seemed like maybe Justice Kagan thought that the regulation was pretty clearly viewpoint discrimination, and I think she was moved by the sort of mirror image hypothetical where you had another state that banned counselors from affirming someone's sexual orientation or preference. And so I think, to your point, I do think it's potentially more than 6 against the law, and the question is how they write the opinion and what happens on remand under a heightened standard of review.
Yeah, but I want to understand the rule that we're going to follow going forward. So psychiatrists and psychologists are going to have some kind of First Amendment protection, but endocrinologists and others will not. I guess that's the rule the court's going to lay out for some of these.
Well, I think they'll all have protection for pure talk related remedies, and none of them will have protection for prescribing medication or surgery. So I think that's the difference.
Got it. If you cut or ingest, it's not speech. If you do the
I don't
talk-
know. Let's just say when I talk to some of my friends, I definitely think I felt some cutting remarks. But I think those are probably still covered by the First Amendment.
Fair enough. Her question was a good one, right? I mean, it prompts some thinking on our side, because for all the transgender health cases, we talk about how a school, for instance, without the parents' knowledge, trying to affirm someone's identity is giving some kind of medical treatment. And that kind of treatment without the parents' consent is not a good thing, is how some folks have framed it on our side. And to Justice Jackson's credit, valid question, right? And it creates an issue, especially because there are other culture war cases that are coming up. The Littlejohn petition, for example, for cert that was filed. It was an instance of a school essentially affirming someone's new gender identity without letting the parents know. And one of the arguments put forward in support of the petitioners is, hey, look, trying to convert your child through some kind of therapy without the parents' consent is the giving of some kind of medical treatment without the parents' consent. And the parents should be informed of it, and the parents should have an opportunity to say no. So there is a tension, right? And the courts are struggling with it. So these aren't easy questions.
Yeah, Eric, one question I have for you on this is, I thought Justice Alito's comparison of deference to the medical consensus here to past cases like Buck v. Bell was interesting. I mean, what is the right balance between judicial skepticism of expert consensus and respect, I guess, for a state's power to regulate a licensed profession?
Yeah, I think that's a pretty interesting question, and finding the line in that balance can be very tough when there has to be space for professional regulation. And I think at least one aspect of the Childs case is that whether you think it's viewpoint or content-based discrimination, there are certain types of speech that are being prohibited and certain other types of speech on the other side that are not. And you pair that with the lack of consensus in the medical community, and that gives states more space to regulate or to act, so long as they are not picking a side. So here you have the lack of consensus plus Colorado making a decision on what views are acceptable or not acceptable. I think that that falls neatly on one side. I think the tougher question is when a state wants to do something that is against the medical consensus, what happens then? Or, again, when we go back to perhaps one of Mo's endocrinologists, when what they're doing is, prescribing a pill or a treatment rather than, talking it out. And, one other tension here is how seriously the court takes therapy, I think was kind of an underlying thread because if one believes that therapy can both be effective but also potentially could cause harm, there's a real desire to regulate that. But if one, and in that way, in the same way that a medicine that heals might also be a poison in the wrong dose. But if you take the idea of therapy less seriously, then it really becomes a lot more like speech. And I have not looked at any of the data as to the efficacy of therapy. My broad understanding is certain types of talk therapy, especially CBT, are effective in some circumstances for some people, and other forms of therapy. Some other forms are less effective in many people. But, as someone who is neither a professional nor, fortunately, I'm not part of this case, so I have not dove in to look at that. It's very difficult to ascertain where the line should be here.
I would also recommend that everyone go back and read Justice Thomas's concurrence in the Scrimetti decision from last year, which, kind of deconstructs the idea even of medical consensus in this space. The sort of medical consensus that that the petitioners in that case were relying on, or not the state, but the challengers, had been sort of politicized. There were certainly ideological viewpoints being laundered into it. So even that concept is I think, is questionable nowadays. So it's something to keep our eye on in this case, because I do think the question of science and what is there a consensus, and who are the experts, and what are their sort of motivations, I think that comes into play, especially in this very politically charged area.
Yeah, and Mark, we're going to keep moving through the program here, but stick with you. Do you want to talk a little bit about First Women's Choice?
Sure. So this case is a really important case for state AGs because it's about their power to issue subpoenas or civil investigative demands, or CIDs, and conversely, the targets of those investigations, their ability to sue in federal court under the First Amendment by claiming that the subpoena chills their First Amendment rights. So this particular case really traces back to 2022, when the Supreme Court overrules Roe versus Wade and the Dobbs decision, and sends abortion policy back to the states. So obviously after that time, Planned Parenthood and pro-abortion groups mobilize with lobbyists and are trying to advocate for abortion at the state level. So around that time, Matthew Platkin is running for Attorney General of New Jersey, and he's supported by Planned Parenthood, and he promises to use his enforcement powers and all the enforcement, civil and criminal enforcement powers of the office to basically promote and protect abortion in the state. He even, one of the first things he does when he takes office is to create a reproductive rights task force, and in partnership with Planned Parenthood, issues a consumer alert against pregnancy resource centers, which are centers that support pregnant women, not by encouraging them to have abortions, but providing them with all kinds of other support. So the New Jersey Attorney General sends out this alert, but then goes even a step further and issues a subpoena into the petitioner First Choice Women's Resources. It's a sweeping subpoena that seeks lots of things, internal communications and whatnot, but also pretty remarkably donor lists and donor contact information and addresses and donor employer information. So if you donated money to First Choice Women's Resource Center, under that subpoena, the petitioner would have had to provide that and your contact information and your former employers going back 10 years. So it's a pretty invasive subpoena, obviously. First Choice immediately goes to federal court and sues under Section 1983, claiming that the subpoena chills its First Amendment rights and that of its donors. Sort of a relatively long and complicated procedural history, but suffice it to say that the district court and the Third Circuit find that the claims are not justiciable at first. They're not ripe because first choice can go once the state attorney general moves to enforce the subpoena in state court. The district court says that's when first choice can raise its First Amendment arguments. And so this case is about, when is a Section 1983 First Amendment claim justiciable when it's dealing with a state attorney general subpoena. And I think this is a really important case because state attorneys general do typically have very broad investigatory powers. They can issue subpoenas, unlike private litigants, who have to wait until after a motion to dismiss stage to get discovery. They can do it pre-enforcement and have a pretty low bar for issuing those subpoenas, typically based on suspicion of wrongdoing, based on what they believe is in the public interest. And so this case is about, well, can you sort of collaterally attack those subpoenas by going to federal court? And, I think it's an important case for how, it will depend on how the Supreme Court decides it. It seems like the momentum is, granted that the state of New Jersey hasn't even filed its response brief yet, but there's a ton of bipartisan support in favor of first choice women's resources because of the potential risk that entities face in any jurisdiction from these sort of broad investigative powers that state AGs have. One last point on this too, it's part of, I think, a somewhat disturbing trend in which state attorneys general have sought to go after politically disfavored groups. We've seen, blue state AGs go after, oil and gas companies against, gun manufacturers, the NRA, against, now in this case, against PRCs. And we've seen the Attorney General of California requiring sweeping disclosure of donor lists from entities, and this was in the Bonta case from a few terms ago. That policy was struck down. So, given how much power state AGs have, I think this will be an important case, an important kind of political case, even though it's there's some procedural issues and it's not one of the sort of culture war cases in a certain sense. I do think it will have a really sweeping effect on how politics gets merged into law enforcement, as we've seen over the last few years.
Whenever folks are talking about going after disfavored people, I always want to bring up at least two other examples if they're not brought up. One is the Little Sisters of the Poor in Pennsylvania, which, despite winning twice at the Supreme Court, are still being persecuted in Pennsylvania. I find that outrageous. The nuns don't want to provide birth control to the other nuns. And then, of course, there's Jack Phillips in Colorado. We were talking a little bit about Colorado's commitment to enforcing its odd view of civil rights against its own citizens. Jack Phillips is exhibit number one. Again, despite winning at the Supreme Court, he is, I think, as of recently, still being investigated by the Colorado Civil Rights Commission, despite the Supreme Court finding they had unlawful animus aimed at him. And people from around the country go to try to pretend to be his customers to then give them authority to sue. It's this is not new, but this Supreme Court case gives another opportunity for the court to cut back against that type of persecution.
And interestingly, in this case, Florida's Attorney General and I believe 17 or 18 other states filed an amicus brief in support of first choice. So, obviously not a real concern that there's going to be any substantial reduction of AG discretion or power. This is really a case, I think, where on the merits, this is pretty clearly an objective chill of free speech when you're asking for, and by the way, the basis for this investigation was the word choice in First Choice Women's Resource Center. You know, that misled consumers into thinking this would be an abortion facility. And I think it's, you know, pretty absurd on its face. But to basically use that as a springboard to then go get its entire donor list. And obviously, I think the donors and the recipients of these subpoenas understand that, you know, quote unquote, accidentally, those lists will get, you know, leaked. And then all of a sudden, employers and friends and family know, you know, what you're supporting. And I think there's a pretty long American tradition of being able to do things without being, you know, without having forced disclosure. So it was interesting to see Florida and other red states, I think, correctly support the petitioners in this case. But it is an interesting question about how the court will draft an opinion to ensure that it's not cutting too far into the investigative powers that are necessary for state attorneys general.
Yeah, and on those donor disclosures, it was always, as an impartial, you know, observer, it was always amazing how those donor lists would always get leaked out on the hot topics of the day. Moving along, Mo, our resident expert on all things political law, Louisiana versus Callais.
Sure. So this case is going to be argued tomorrow by one of Eric's colleagues, and this is a case that was relisted for this term. The case centers around Louisiana's 2024 congressional map. The reason why they had a map in 2024 is because their map after the 2020 census was found to have violated the Voting Rights Act by one court. This is the Robinson litigation. And so Louisiana went back to the drawing board. They came up with another map in 2024. And the goal was to, as the argument goes, the goal was to draw another majority Black performing districts. The second majority Black district happened to snake 250 miles from the southeastern corner of the state all the way up to the northwestern corner of the state. And that second map got challenged in a second lawsuit. And the argument was that this map that Louisiana passed in 2024 violated the U.S. Constitution. Louisiana's attempt to comply with the Voting Rights Act violated the U.S. Constitution. A three-judge panel agreed, and the U.S. Supreme Court happened to stay the effect of the decision so that Louisiana could use the 2024 map for its 2024 election. And so in March of this year, Louisiana argued the case and defended the 2024 map, in part by talking about how, hey, look, at the end of the day, we were just trying to comply with a court order. We're trying to comply with Section 2 of the Voting Rights Act. We should be given some breathing space in Voting Rights Act parlance to come up with a map that furthers our interest in trying to comply with the VRA. The case, as I mentioned before, it got relisted, and the question the Supreme Court asked the parties to brief was whether, quote, the intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments to the U.S. Constitution. The interesting thing about this case now is that Louisiana is now arguing that, hey, our 2024 map wasn't that great. It was race-based redistricting. And race-based redistricting is unconstitutional, even if it's done to comply with Section 2 of the Voting Rights Act. The Robinson plaintiffs, who challenged the first map, are interveners in the case, and they are defending the 2024 map. You've got the Callais litigants, the plaintiffs who started this case, making their points. A couple of big things at play here are, for the last few decades, as Justice Thomas said, for the last 3 decades, he's essentially been arguing that the VRA is at war with the Equal Protection Clause. The fact that this case was relisted, Brown versus Board was relisted, Roe was relisted, Citizens United was relisted. So there's some thought that maybe this is going to be a blockbuster case, and I love Eric's thoughts on this, about whether or not this is perhaps going to be a blockbuster case where we have Justice Thomas's view be the law of the land, or is this going to be an instance where the court tells us, that, hey, there is a line between being race conscious and race predominating, and we're gonna, give you some more guideposts on when race consciousness becomes impermissible race predomination? Or is this just going to be some kind of explanation of how the jingles factors, which come into play, are actually to be applied? And I'll hush up there, and I'm curious to see what the group thinks.
I have two thoughts. One is I have a very unpopular in my cohort, not my SG cohort, opinion that people just shouldn't be treated differently based on their skin color. And so if you are choosing who gets to be a voter or who gets to be elected based on their skin color, my strong presumption is that somewhere along the path, you as the person making that decision have erred. I think the Supreme Court largely or is inching towards a kind of colorblind type approach to many areas of law, and that this would be a step in that direction. It is notable, though, that the Solicitor General offered a more modest approach than what Louisiana suggested, basically to recast jingles. Um, I think it's not implausible that that's what ends up getting 5 votes, but jingles is not an originalist opinion. It is not clear where in the text of the Constitution jingles comes from. So it seems pretty weird to recast jingles. If you're going to be doing something to recast or undo current precedent, one would think you would try to get it right instead of trying to fix something that you're saying is wrong. But I think there's going to be a lot of tension there. There's a lot of extremely well-deserved warm feelings towards the various civil rights laws that were enacted in the 60s and 70s. And there is trepidation about undoing what has long seemed like bedrock civil rights law. So I think there's going to be a tension between originalism and institutionalism, and at least from my perspective, the conservatives on the court are split evenly on their preference between those two. And so it'll be interesting to see where things end up. And of course, there's always the other outcome, which is that you get a really bad split decision that no one really understands, and they're just going to have to take another one of these cases, in a year or two to help clarify further.
All right. We've got 2 more cases and we're running short on time. So I'll kick it over to Brandon to talk about the New Jersey Transit Corp case.
Yeah, this is of course the most exciting case on the docket today, the New Jersey Transit Corporation tort lawsuit, where Cedric Galette was hit by a New Jersey transit vehicle and tried to sue, only to run into a number of oppositional problems. New Jersey Transit argued that as an arm of the state of New Jersey, it was therefore immune from suit under interstate sovereign immunity. The Pennsylvania Supreme Court agreed, holding that New Jersey Transit can't be sued in another state's court. Supreme Court's going to really have to decide the core question, which is, when does a state-created corporation become an arm of the state entitled to sovereign immunity? And when is it just a state-owned business that should be accountable like any other defendant? This arm of the state doctrine has almost a Breyerian multi-factor test to it. One is a creation and control, a question whether the organization was created by statute or is tightly controlled by the state. 2 is sort of the treasury liability. Would a judgment be paid from state treasury if they were found liable? 3rd factor is function. Does it perform core government duties, or does it operate more commercially, more in the marketplace? And kind of the final 4th factor is about autonomy. Does it act independently, or is it actively under government or state supervision? And Galette, New Jersey Transit, emphasized its public mission, its police powers, its state oversight, but the plaintiffs had argued that it operates essentially like a commercial carrier, charging fares, entering contracts, creating opportunities for consumers, and managing its own budget. there's a bit of a parallel here to the Mohila case in the 10th Circuit. This is I always forget, Missouri Higher Ed Lending Authority. Mohila, of course, had some great fame earlier this year in a case that Eric was also involved, or a couple years ago in a case that Eric was involved in. But in this case, plaintiffs had challenged Mohila for violations of the Credit Reporting Act. And the 10th Circuit rejected immunity, finding that Mohila was financially independent and was not backed by the state treasury. So the contrast here is that Mohila, an independent, profit-making, no treasury exposure, got no immunity. But New Jersey Transit has core infrastructure role, subject to state control, serves a government or public function, and therefore potentially has a stronger immunity claim. There's sort of like some bigger picture themes behind these questions on sovereign immunity here. Sovereign immunity really isn't a loophole. It's a structural safeguard of federalism. The framers saw states as co-equal sovereigns, something that's a super popular concept today. But they're not supposed to be subject to one another's courts. If every state could drag another state's agencies into court, state sovereignty would be sovereignty in name only. There's also like a real issue, I think, here in predictability and accountability. The test really needs to be clear. Who pays if the entity is sued is a good way to think about that. Treasury liability provides an objective rule. It aligns accountability with fiscal responsibility. If the state treasury is on the hook, then immunity perhaps should attach. That rule ties accountability and fiscal responsibility to at least provide some guidance to states on what to expect. But I think there's also a broader sort of separation of powers question that courts really shouldn't be expanding or contracting immunity claims based off of sympathy for a particular injured party or policy purposes. Immunity doctrine really should come from our constitutional structure, not from a sort of complicated judicial balancing test. And courts can't really rewrite state accountability rules just because they dislike immunity outcomes. There are statutory and legislative methods for resolving concerns that we might have about when the state is immune from liability. I also think it's going to be important to see how much this decision ends up limiting hybrid abuse. Like the Mohila example, which is one of the most ridiculous organizations out there, shows the danger of states creating sort of quasi-private corporations that seek profits like businesses. They act in the marketplace, they're competing for consumers, but then they try to seek to hide behind sovereign immunity when sued. The law should protect the sovereign, not just the sort of corporate bureaucracy that we see in this sort of hybrid models. So the court's decision will ultimately, or in theory, could define how far state immunity really travels across state lines, how much protection quasi-state entities or agencies can claim. A broader ruling would protect state dignity, but I think limit access to remedies. A narrow approach to immunity could promote accountability for state agencies, but I think it's going to radically increase state exposure, legal risk as well. So either way, it could potentially reshape the balance and how we see this going forward. But I know we're running low on time, so we'll maybe close up there and let David just kind of offer some final thoughts, perhaps.
All right, real quick though, I want 30 seconds from Eric on the case Montana's arguing tomorrow, did the other state case that's on the docket.
Yeah, Montana Solicitor General Christian Corrigan is arguing about the Fourth Amendment standard to do a wellness check on a potential situation. Some police officers had a call of suicide. There was some evidence that maybe there was an attempted suicide by cop. They went to check on the person and he jumped out and they shot him. And now the question is whether they were entitled to enter the home at all. I am very much looking forward to listening to the argument tomorrow. The Supreme Court has been allergic to Fourth Amendment cases, and reading Montana's briefing and the excellent briefing on both sides, there's a real tension in the law in applying the Constitution and what standards should apply for this non-criminal behavior. And so getting a sense of where the court is, I think, will be vital to seeing where the future of Fourth Amendment law is going.
All right. Well, thank you to my fellow panelists. Great discussion, Vera. I'll kick it back over to you.
Thank you. On behalf of the Federalist Society, I want to thank our experts for the benefit of their valuable time and expertise today, and I want to thank our audience for joining and participating. For anyone seeking CLE credit, the attendance reporting form has been posted in the chat box, so please complete that form now or immediately following this webinar. A COA with your calculated CLE credit will be emailed to the address you provided within 1 week, along with any pertinent CLE credit reporting information for your specific state. If you do not receive this follow-up, or if you have any additional questions, please contact us at cle@fedsoc.org. That's CLE as in Charlie Lima Echo at fedsoc.org. As always, keep an eye on our website and your emails for announcements about upcoming virtual events for the In-House Counsel Network. Thank you all for joining us today. We are adjourned.